those of you that are joining with us. We have Ashley and James with Brewer Law Firm, and they're going to be talking with us this afternoon about flipped homes, buying and selling. I think we've all seen the HGTV shows and all the other shows, and on marketing meetings, I hear a lot of people say, oh, I'm looking for a flipped home, or, we're looking for those types of things. So they're going to give you some information about what to look for when buying one of those homes, and also if you're going to sell one, disclosures and things like that. So I'm going to turn it over to Ashley first, and she'll introduce James as well. If you have any questions for them, please use the Q&A box at the bottom, and I will be monitoring that. If something comes up, I can interrupt them and ask, but please, interactive, so ask your questions. And Ashley, welcome.
Hi, thanks for having me. I'm sure maybe some of you have seen some of my prior talks. I typically do presentations about, local tenant protections and generally landlord-tenant law. We decided to switch it up today because by and far the most expensive and most contentious non-disclosure cases we've been getting within the last year or so, and really it's been longer than that, are when people are buying and selling flip properties. And that comes due to lack of proper disclosures, lack of proper investigation, and we'll get into all of that. And we'll also tie in a little bit of the landlord-tenant laws because it is relevant if you're buying or selling a flip property, especially in this area with how the rental market is. But first, let me introduce myself. My name is Ashley Gonzalez. I've been with Brewer, Offord and Pedersen for almost 6 years now. Since I started practicing, I've done exclusively real estate. I do everything from partition actions to non-disclosures, evictions. We do some transactional law as well as, drafting leases and basically everything that involves real estate. And as I mentioned, I've been here for about 6 years and have seen a lot of these flip disputes, so to speak, for lack of a better term. And hopefully we can provide you with some information that can help you and your clients moving forward. And with that, I will let James tell you a little bit about himself. He's one of our associates at the firm.
So hi guys, this is probably my second speaking engagement. I've been with Brewer Firm almost a year at this point. I think it's 3 months from my anniversary. I've dealt with a lot of disclosure cases, maybe 5 or 6, maybe even in the last half year, and I've handled plenty of landlord-tenant disputes with Ashley. Seen a lot of complaints, a lot of allegations from plaintiffs' attorneys, alleging tenants' rights. Been on the other side, defended a lot of unlawful detainers. We're currently in the middle of negotiating a settlement for many of our, one client, needs extra attention, and especially also with the COVID, there's a lot of new rules to navigate in the meantime. So I've been learning, and Ashley has been learning as well. So we are really happy to be here today.
Thanks, James. So first, we're going to start off. I will do a breakdown on if you are buying a flip property, and then James will go into if you're selling, or if you're a flipper, or you're someone that renovates homes and sells them. He will give some information on that. And then at the end, we'll go over some agent concerns, things you can look out for, things not to do, things we've seen agents sued for. So hopefully we'll be able to give you a pretty big overview of what to look out for on either side, and also as the agent. So first, if you are buying a flip, and in my opinion, this is by far the more risky option, and we can explain why. But I broke it down into 2 segments. Number 1 is if you plan to live in the residence. And then second, if you are buying an investment property, if you plan on renting it out, either with the current tenants or with new tenants. So first, the biggest thing that you can do as the buyer or the buyer's agent is to review the property history, and primarily the permit history, and then any and all contracts you receive from the seller, or any estimates, repairs, details about that, any inspection reports received from the seller. But one of the biggest things that comes up in lawsuits, and it's kind of a shoulda, coulda, woulda type arrangement, is the permit history. And just so you know, a lot of this information is public record. You just have to go to the city or county and request it. Sometimes with COVID now, you have to do it online, and there could be a little bit of a delay. For example, I just did one for Los Altos, and they said they would get documents back to me within 10 days. So it's a little bit of a delay considering how transactions are going. But if you are buying a flip home, it may be an extra step that you want to take. And also, if you want to do that for your clients, go and pull the permit history, because if you know work has been performed recently or over time, and substantial work, which is usually the case for a remodel and a flip sale, pull those permits, because the last thing you want to do is get into a property not knowing whether or not the work performed by the flipper and their vendors was permitted or not. Because in some instances, the city can come red tag the property until you bring it up to code, or even worse, the work can cause damages. It can fall apart, pipes can burst, those types of things. I think it's important to know and understand as a buyer and as the buyer's agent that these flippers are interested in getting into the property, getting the work done, sometimes as fast and as cheap as possible, and then offloading the property. And sometimes that comes with unlicensed contractors, sometimes that comes without permits. And so there's a little bit of a fast and loose game going on. And as a buyer, just try to make yourself as informed as possible. And also as a buyer's agent, offer that service and say, hey, I pulled the permit history, the work they described on their listing, it's all legit. There's permits for that. They pulled that. But I will say, and James will probably agree with me on this, is that I would say anywhere from 75 to 80% of the time, there's permits that are lacking for whatever, the case may be. They do a gazebo in the backyard, or they build some kind of converted shed that's now being lived in, those types of things. And that could be a big issue. I can give you an example. My clients bought a property all cash, and it was advertised as a 4-unit building. It was a flip. The buyer went in, renovated the units, made them, converted them to residential, and advertised it as a 4-unit. And my clients, for whatever reason, didn't pull a permit history. Neither did their agent, and they bought the property all cash, which is not uncommon, especially for this area. And then they had the intention of refinancing the property, getting a loan, cashing that out, and then renting out the 4 units to tenants. Well, when they went to get a loan, the lender would not give a loan for the property because it was only zoned and permitted for 3 units, but it was listed and described and built as a 4-unit property. So as you can imagine, boom, here comes the lawsuit, that the seller didn't disclose the proper qualifications for the property. But there's also arguments to be made for my client that he could have gone down to the city and seen that there were no permits pulled for this renovation, and it was zoned and permitted for 3 units. So that one ended up resolving in mediation, thankfully, but I think it would have been an interesting case because of your duty as a buyer to investigate under the law. Again, I know it's hard in this market to do your own independent inspections and to have the inspection contingency, but if you're buying a flip, it would be my strong recommendation to do that. At least get a home inspection report. The biggest dispute that I see coming up are foundation issues. So if you need to get a structural engineer out to the property, all these types of things I think are difficult for buyers because you're buying a property from someone that did not live in it. And so they may not know as much about the property as a typical seller. So if you can add the inspection contingency, do it. But even before that, if they're not going to accept it that way, do your own inspection reports, either home inspection, foundation, whatever you have to do. Just be aware that, as I mentioned, the seller did not live there. And so their disclosures might be a little bit more bare than the typical seller. And then one other important note that I think that you should try to do if you're buying a flip property, or if you know that they bought it fairly recently is ask the flip seller for the disclosures they got when they bought it. So if they bought it 6 months ago and renovated it and are now listing and selling it, those disclosures that they received when they bought it are, in my opinion, relevant and material to your purchase. So you should ask for those. Whether or not they provide them, you can make your own independent decision on that, whether or not to move forward. I think that's a bad sign if they don't. Also, your agent may be able to pull them from the MLS if they're still uploaded as disclosures. So have your agent ask their agent for those documents, and then also check online to see if they can pull them themselves. I think those are super helpful because at some point the chain ends, right? So the flipper probably bought it from someone that lived in there. And so their disclosures are definitely going to be more robust. So you want to get your hands on those. Now, if you're buying the property to rent it out, there's some additional things you need to look out for. As we all know, and you probably heard a dozen times or more in talks and presentations, is that there's a lot of tenant protections right now, specifically Senate Bill 91, and that doesn't end for another month or so. And even after that, there's some rent protections that go forward, and Santa Clara County also has their own protections that I think will kick back in once the Senate bill ends, so to speak. But make sure, number one, that you're aware of those laws. And if you're buying a property that has tenants in there, make sure you know your rights concerning those tenants. I think there's a big misconception, and I have clients come to me all the time. Hey, I want to buy this property. It's a 4-unit building. There's tenants in there. Here's their SOPL certificates. Can I get these people out? I want to get new tenants in at a higher rent rate. It's a super common question, and it's legitimate. And I say, well, number one, what does their lease say? Because that dictates everything first. But say if they're a month-to-month tenant, at least for right now in all of California, you need just cause for most properties. There's some that are exempt, like single family and other specific properties outlined by the statutes. But it's important to know that in order to get tenants out right now, for the most part, you need cause. And so you can't just get in there and buy this flip property that has tenants in and have the plan to kick them out, because more than likely you're going to get surprised by that and end up having the prior tenants being able to stay at their current rent rate. So that's a big thing to really educate yourself on. And also for buyers agents, make sure that they know the laws regarding tenant rights. And if you don't know them that well yourself, refer them to an attorney. Like, we'd be happy to help either during or before the transaction, preferably before, because once you're in, that would not give you cause to back out unless you had an inspection contingency. So make sure your clients are informed of what's going on with these transactions. And then just a couple examples I think are important to know. We have a couple cases going on, and one that I wrapped up before. I had a client buying a flip home, and it came out that there were significant foundation issues. And what the flipper did was, he did pretty surface level work. He installed new carpet, and then he painted all the walls, and by doing so, he covered a lot of cracks. So there was obviously some liability there on the flipper for concealing facts that would lead to someone to believe there's a foundation issue. But even worse, my client's agent didn't really inform my client enough of how that sale works, that the flipper didn't live in the property. You should do your own inspections. He had, I think, a 20-day inspection period. And this one was a little bit wonky because that agent and my client said, hey, this flooring looks a little bit sloped. What's going on? He asked his agent, which in hindsight, we should have gotten an expert out there. She took a ball and rolled it on the floor and said, look, the flooring is fine. It's rolling normal. And I thought that was such a kind of outlandish thing to do as an agent and to try and ease your client's concerns. I thought that was strange. And as you can imagine, that ended up being an issue for my client's agent and also for the seller, because he painted over cracks and did not disclose them. But getting into that property, it would have been helpful if my client, had done his own inspection reports and a foundation report, because like I mentioned, these people aren't living in the home, so they may not know as much as the typical seller. And for all we know, and we weren't able to prove it, we never went to trial, we ended up settling at mediation, is that the flipper could have said, hey, I never lived in there. I hired painters when I bought the property and they painted it. I wasn't there when the painting was done. For all I know, I didn't know the cracks were there. So there's some difficulty in proving these disclosure cases when the seller, as I mentioned, did not live there. So you want to be careful of that. Another one we have right now is it revolves around a pool. The flipper bought the property, renovated it, and throughout their ownership, the pool would constantly leak, and the guy just kept filling it up. And he didn't disclose that to my clients, but thankfully in that case, my client had some diligent neighbors and they had seen him constantly filling the pool. And so that was a unique instance where we do have some proof of that non-disclosure. But again, that's a hard one to prove when he's not using the pool, he's not living there. So if you are a buyer, it just shows how important it is to really investigate and get your own independent inspection reports, because it's the burden, I think, is more difficult in these cases because of the lack of knowledge, because all the seller has to disclose, as you may know, is what they know. So, and then proving what they didn't know in that short duration of time of remodel is difficult at times. And then with that, I will move to James, and he will give us some information for if you're selling a flip property.
So we do have one question that came up. I figure we'll ask this, and then maybe James, maybe you'll cover this. But do contractors, a lot of times, no matter what you're doing, they will stand by their work, and there is some type of a warranty. Is there any way to go back? I guess if you're the seller and you did the flip, and the buyer has an issue, you should be able to go back to that contractor, hopefully.
Yeah, so if the buyer brings a claim against the seller for work that goes awry, you do want to ask the seller if their contract came with a warranty, because if it's within a set duration of time, I mean some of them I think are 10 years for some work. Just depends on the contract. But number one, yeah, you want to make the seller refer back to the contract, but that brings up a good point, Jody, because arguably I think that contract, if the work was done fairly recently, I think that should be included in the disclosure package, and that would be the most prudent thing to do as a seller, is just provide that contract. And if something goes wrong with the work performed, the buyer can contact the contractor directly, because more than likely how the contract is written with the vendor is that the warranty rights are assigned to the new owner. And so they would actually, depending on what the contract says, be able to work on that directly without the seller involvement.
I think that's a good reminder for people is you can't just work on a handshake deal. You can't do that, especially if you're doing things like this. Is you need it in writing and include that warranty. And I'll just ask another question on that. Are there implied warranties, or are there 30-day warranties on things, or is that a case by case, contractor by contractor thing?
I think this is James' sweet spot. You want to give a little information on
that? Just a little, not too much. Don't want any spoilers, but in any sort of contract, there's I guess a implied warranty of, good workmanship, right? Everyone sort of has a duty not to, perform their contracts and their undertakings negligently. So even if it doesn't say, in a contract that, that the work shall not be negligent, well, it's implied, right? That no one's paying for negligent work. And they may also certainly depend, there are statutory protections to any sort of contract for work performed on, I guess, the residential premises. Usually the contract should come with a 3-day notice of rescission. So that's a statutory protection. The problem is if it doesn't contain it, right, how are you as the homeowner supposed to know? Well, I guess we told you today that generally you have a 3-day, right to rescind the construction contract. So you can see that in the contract, there are sort of implied guarantees, right? Everyone's supposed to do what they're supposed to do properly. And generally, there are additional statutory protections under the Business and Professions Code.
And if I can add to that,
Yeah.
an important code section to know, because I've researched this recently, is Civil Code Section 896. Just for example, and this is the particular issue I researched, is that under that code section, things like pathways, driveways, sidewalks, patios, they have a 4-year statutory warranty. And then I'm looking at it right now, things like paint and stains causing deterioration, that's a 5-year warranty. The 10-year one, it looks like it includes foundation systems, retaining walls, support beams, those types of things. So there are statutory warranties, but the way to look at that, if you have any experience in these kinds of cases, it's kind of like a statute of limitations. So if you have an issue come up with a defect or from repairs, you want to make sure you bring that claim within the statutory amount of time. So if you have a driveway that's cracking apart and it's been 3.5 years since you got the work done, well, you have about 6 months left to bring that claim. So just be careful that if your clients are having issues, that you meet that deadline. So and we can help you with that. But beyond contractually, there are some statutory deadlines, so to speak, for those warranties.
Right. I believe the section actually refers to the Right to Repair Act. So that generally applies to new construction. And since, the topic of our discussion today is, flipped homes, then the Right to Repair Act would be one of those statutory remedies, beyond the contract.
Complete tear down build up for that kind of situation. Okay, James, you want to go into for sellers of flip homes?
So these are for the flippers, the sellers. So if you consider, I guess, a rental property, right, either as a residence, the owner's residence, or perhaps as an investment opportunity, you may consider, I guess, not so much as a problem, but sort of the existence of tenants already in the building. I think, seeing enough litigation, one of our largest concerns is really avoiding the violation of tenants' rights. I'm sure we all know tenants have, the right to habitability. They have the right to quiet enjoyment. They do have the right to electricity, heated premises, running water, all sorts of, statutory protections that, California has given them throughout the years and decades ago. So even, let's say, even if you think it may not be an issue, usually it can be, because there are a lot of, I guess, things tenants can allege. Like, for example, there's a current lawsuit where the tenant, themselves moved out of the property. Then they turned around and sued the landlord for not giving her, let's say, proper just cause, even though they did give her rent relocation assistance. And, Ashley and I know it's only a $435 ticket to, the Superior Court. So really anyone can sort of get in to a lawsuit, regardless of, whether you think their case is merit or not. And we should also note that there are a lot of statutory provisions, especially one for retaliatory eviction that's under, I think, CCP 1942.5. Those come with mandatory attorney's fees. So, a lot of the time, you may think your tenant doesn't really have the funds to take on a case, but there's going to be a tenant's attorney that will take the case completely on contingency. And those cases are very expensive to defend. And, and at some part of the calculation, as the landlord, you may think, okay, well, is it going to be cheaper to pay my lawyer or to settle the case? And usually it's going to, plaintiff's attorneys know it's okay, well, they're going to pay us some amount to settle the case. So is there a way to sort of completely avoid liability for that? No, we don't, it comes and goes. But I think the most important thing is to document all your interactions with the tenants, or even, the future tenants that you may inherit if you're purchasing or if you're selling. You really want to show that you're a good landlord, right? Over emails that you were responsive to all their repair requests. You just don't want to give them any reason to go after you. Also, I believe Ashley mentioned this, but Senate Bill 91 creates even more protections recently, and especially with, I think it's Assembly Bill 3088 that extends the tenant protections for COVID-19 related rent. So I guess most relevant to our case is that there used to be an exception for no just cause eviction, which is if a landlord wanted to substantially remodel or renovate the property, they'd have to give the tenant notice, and then they'd have to help with some relocation expenses under California law. Certainly this might be different if you're in a sort of more restrictive jurisdictions such as the city of Oakland or the city of San Francisco. But that used to be a reason you could sort of tell a tenant to vacate. Now, Senate Bill 91 suspends this no just cause eviction unless you sort of need to redo the place based on health and safety violations. So getting sort of existing tenants, being able to remove them to put the property up for sale is now more difficult. So assuming that the property is going to be sold with tenants, it's important to disclose, certainly, as Ashley mentioned, disclose the existence of the terms of the lease to the potential buyer. It also, I guess that if the bank is going to finance the sale, which we're always going to get financing here, then it's important to obtain a estoppel certificate from the tenant that states, okay, well, this is how much I'm paying every month in my rent. This is how long my rent lasts. So that's important, financially, especially if the property is going to be sold as an investment. The future landlord wants to see, what's the income stream. And certainly this would be a very material disclosure if they make, I guess, their intent to use it as an investment property known to you. Next, it's important to not promise vacant property. Sometimes, you have a fixed term lease, right, from a tenant that went on for way too long. It's probably it's a 5-year lease and they haven't raised the rent since 2016. And maybe they're paying under $2,000 for a 1,000 square foot in San Jose. And that might, for some part, turn off some buyers of the property, especially if they're seeing okay, well, I can't really use the rent to offset some of my costs, such as mortgage and property taxes. So you really want to make sure the buyer has an accurate picture of what the expected income stream from the property would be. Let's see. And furthermore, it's important, and the fear of litigation aside, it's important to keep good relationships with your existing tenants, because certainly as part of the disclosures and the visual inspection, the buyer's agent, they may want, of course, a walkthrough of the property that's being sold. They want to see probably the condition, right? They want to see whether this tenant is someone who's easy to work with, whether this tenant is clean, whether there's concerns such as, maybe animals or, general, habits of cleanliness. So it's important to just stay on good terms with your tenants during this time. And I briefly mentioned this, but it's also important to check if your property is in a more protective jurisdiction, such as Oakland or San Francisco. Hopefully, hopefully at this point that whether your property is a condominium, an apartment, or whatever category your city has given you. I guess the significance of this would be certain types of housing, they basically get more protection than California law gives them. So if your tenant is in a condo, right, but it's categorized as an apartment based on the certificate of occupancy or other characteristics, it's important not to violate those local rules as well, since they can be used as a defense to any sort of unlawful detainer action. And I guess since COVID hit, the trend really has been California's ratcheting up protections, and these aren't likely going to disappear anytime soon, even though there's phase outs in the current plans, but the impact of COVID-19 probably will last for at least 2 years. And it also can't be emphasized enough that you should disclose. If you're a dual agent, you're in a unique and dangerous position. There's the prospect of getting a double commission on the buy and sell side. That's very enticing, but you also should know that the seller's agents, they have a legal obligation to both even to the buyer, to disclose what they know. So it's basically a fiduciary obligation that runs both ways when you're the seller's agent. They're entitled to sort of full disclosure without any sort of concealments or half-truths. Really, the only exception to that rule is that if something would be evident from a visual inspection. But even so, as Ashley pointed out, if you paint over a crack, a visual inspection may not reveal deeper underlying problems. And again, the same matters of disclosure should be presented. You need to inform the buyers of the nature of any work performed on the property, even though you may think, okay, well, it's over 20 years ago when we had that foundation problem. The failure it's not the fact that it was 20 years ago, it's the fact that you knew about it and didn't disclose it. In terms of the biggest ticket item in permitting, that would be disclosures. We have a case, I'm working with that case with Adam. He's another partner at the firm. So it's basically the buyers of a property are suing our clients for $500,000 because they think we didn't disclose a permitting issues in the 1980s, right? You may think, okay, well, did they buy the property in the 1980s? No, my clients didn't buy the property in the 80s. They bought the property fairly recently in 2015. So what they did was they sort of sat on the property, they sold it 2 years later, right? You want to get capital gains on, the profits. So they sold the property, and the subsequent buyer then discovered, oh, okay, well, there's an unpermitted addition from the 80s. So then they sued our clients. You may think, okay, well, how much will it really cost to fix an unpermitted addition from the 80s, right? If it's just like a cottage or a side of the house. Well, the issue with these non-disclosure cases is that when you don't disclose that something is unpermitted, they can then tell you, the government can tell you to fix the entire problem, including the costs of getting the building up to code. You see, generally, when there's new regulations or rules enacted, the existing building is grandfathered in. So what seems to be, a $1,000 fix, if you fix the house in 1980, can turn into at least a $50,000 fix if there's 25 new rules to comply with that's been enacted over the years. So you can see that a failure to disclose unpermitted addition can cost you way more than any commission or any profit on a sale is worth. I guess the final reminder here would be the choice of contractors. You always want to use licensed people. Certainly, unlicensed people cost a lot less than licensed people. But the issue is, if work is performed without a license, you'd have to disclose that to any prospective buyers. That inherently reduces the value of the property, and it really casts doubt on whether there was any permit issued for the same work, because the city will usually require that the contractor submit a plan and a proposal and give them their contractor number, right? And it's, we live in the age of the internet. It's very simple to verify whether someone is licensed or not. And if they're not, well, city's just they're gonna deny the permit, right? That's a simple no. So you should always use licensed people to do any work.
I think you just learned a lot in there. Are you, can I ask a question really quick? Because
Yeah.
you mentioned licensed contractor. There's a question in here about handyman. So do handy people have to be licensed as well? And do they follow these same guidelines?
So it's a good question, and I think I'm going to give you a complicated answer to something that should be fairly simple. But generally, if the total cost is more than $500 for any sort of home improvement work, you need a license. If it's under, probably not, but certainly. So here's the complicated answer. The CSLB, the California State Licensing Board, basically tells you what work needs a license and what work doesn't need a license. So I guess that's the answer, right? Check the governing agency if that kind of work needs a license. And I guess if it's a handyman anyways, I mean, it would make sense they should have a license, because I mean, what are they just never going to do any project more than $500? I mean, even if they are, right, even if they do something under $500, they should be licensed ideally.
Mm-hmm.
So I mean, I don't think there's a reason they shouldn't be licensed if they're doing any sort of work.
Thank you.
Yeah. I'll just continue. There are also statutory protections to any sort of home improvement contracts. For example, I mentioned earlier, you have a notice of a 3-day right to sort of cancel the home construction work. If they don't have that in their contract, that's a red flag, because if you're not, following the most basic, the basic law that gives the consumer notice of the right to sort of cancel the contract, then you're probably not going to follow the other, more important points. Additionally, there's also a 10% or $1,000 limit as to a down payment. For example, if you sign a contract for $200,000 on a home remodel, right? And they say, well, give me 10% down, $20,000. You think, okay, well, that sounds reasonable, because they got to pay for the workers to come here, and they got to sort of, pay for the materials up front. Well, that's too bad because the law says they're only entitled to collect the greater of 10% or $1,000. Sorry, the lesser of 10% or $1,000. So even if it's a $200,000 home remodel project, all they can ask for is $1,000, upfront. The next thing would be, and this happens a lot, that the work is progressing on the house. Maybe some unexpected event happens that, okay, well, the cabinets don't fit here, so we're going to have to go remove and get new cabinets that fit, or the roofing doesn't match the color of the walls. So in that case, you're probably going to need a change work order, which means exactly that. You're going to have to change the scope of the contract. So any sort of change work order needs to be in writing. It can't be just oral. It has to be in writing. It has to be presented to you, and you have to basically sign and approve the change of work. There's cases where the contractor does the work, and then what they do is they send the change work order afterwards, right after the work is done, and it's $10,000 above the contract price, and then the homeowner gets upset, and then the contractor gets upset because they didn't pay the extra $10,000 that the contractor, I believe, actually spent in performing the job. So it's important to know, I guess, what the law is, and to go with a contractor that will respect, California law. It just avoids problems down the road. And I think the final part, we'll turn to Ashley for any sort of agent concerns on these transactions.
Okay, so SCORE has actually done some great presentations, I believe, with the District Attorney's Office of St. Clair County. And they tied in what James mentioned about if the work is $500 or more, the contractor, even the handyman, needs a license, and there's some steep penalties if work is performed without a license. Whether or not those are prosecuted criminally, it's really not worth it to be involved in that, because the DA's office has a real estate fraud unit, and they also do focus on unlicensed work, especially in this area, and they take it very seriously. And so beyond civilly, which we are living in and what we practice, there are some implications criminally where they do at times crack down on that. So you want to be very careful. I think they do an annual presentation, maybe because of COVID. That didn't happen last year, or I missed it, but Jody can probably provide more information on that. But really, it's also has criminal implications, so be very careful. And then another thing I see agents doing, and that can get you in a lot of trouble and get you sued, is coordinating the work. So you have a client that buys a fixer upper, and they have the intention of remodeling it and selling it. And then what happens is the agent wants to go above and beyond, because you do have a fiduciary duty, and they're getting the contractors out there. They're getting the painters, the plumbers, all those people, and they're at the property. They're directing the work. They're coordinating everything, right? Because you got that commission for the purchase, and then you're going to get it for the sale. And so you feel like you have this obligation to go above and beyond. But that comes with its own issues, because in essence, you would be kind of like a construction manager, and that type of role would require a license. And there's more specifics to that, and you can look at the CSLB website. But what we would recommend from our standpoint, because we've seen the worst of the worst, is to have the owner do that if they can, because there's an exception to the license requirement where owner builders do not need a license to perform that type of work, to coordinate the remodel. There's an exception for owner builders. So that's one thing. It's pretty surface level as far as the information and warning I'm giving you. So if you need more information, let me know. but just be careful with coordinating that remodel because you're not licensed to do that. You're licensed to practice real estate and conduct transactions. So you just want to make sure that you're wearing your hat and not the lawyer hat, not the contractor hat, and all these things. I know it's tempting to do that because you want to provide a good service, but just be careful. Next one, and I have specific experience in this, is be careful who you refer to your clients. Number one, please refer licensed vendors if you're going to do it. But beyond that, you just really want to be careful because sometimes you could be held liable because if you refer a contractor and he does, less than standard work, the client may come after you and say, hey, you referred this guy, but for you, I would not have used him. Most instances, if you knew they had a license, you checked that and everything was up to code and you referred them, at that point, I think you'd have some arguments to put the blame on the contractor. But there was a case that we went to a jury trial and it was about 3 weeks in court. And my client had referred a contractor who he believed was licensed. He had a business card on his truck. He had a magnet that said so-and-so construction, and he put the license number on there. And he had a buyer. He represented the seller, but the buyer came in and wanted to renovate the property and had plans. And my client was like, yeah, hey, I know a guy. Here's his name. And go to find out, the contractor was using someone else's license, identification card. It was pulling permits fraudulently on behalf of some friend or contractor that had a license. And he was operating under a different name. It was this whole scheme. And of course, the contractor didn't do great work. He didn't even finish. And so the buyer sued everyone under the sun, my client, the client's brokerage, the seller, everybody. And the jury ended up ruling that my client was not liable. So that was great. But he had to participate in that trial because he referred the guy. And even though he didn't know what the guy was actually doing behind the scenes, he was involved. And as an agent, you really don't want to be involved in a lawsuit if you can avoid it. Sometimes makes your premiums go up for your E&O. So our advice is primarily intended to keep you out of lawsuits. In addition to, even if you can defend it, if you have defenses and there's exceptions and those types of things, we don't even want to see you in that situation. And so if you want my best practice, I would say don't refer anybody, but I know that's not practical. So if you are going to do it, just make sure you're vetting them. You make sure their license is current and you're able to, get their card that has their license number. You look it up, you verify it. Just make sure you're doing all those things to try and protect yourself. And then with that, I think we can open it up for Q&A. Jody, you want to jump in?
Yes, and I was just looking for the website. SCORE does have an affiliate guide. So I will share the link to that, and those are all licensed contractors. So you're more than welcome to go through and pick one. They all have their own licenses, so that you can make sure you've got somebody. There's a question in here, in the case of new builds.
Yeah.
And I used to work for a new home builder. Are builders still offering warranties?
Well, as we mentioned, the code section I mentioned, which was Civil Code 896, that's a statutory warranty. And so if essentially how it would work, my understanding is that you have a statutory warranty. And so things like I mentioned, the driveway, right? Like I know people that had a driveway that was splitting apart and they bought the property in 2016, and I had to tell them like, hey, you're out of luck because it's beyond that 4-year warranty period, and it was a new build, and there was nothing in the contract that stated that there was a warranty for the driveway, so we had to refer to the code. But essentially it's what's in the contract or the statute. And unfortunately, my review of more recent new build contracts is they're very seller friendly. They're very builder friendly. I mean, as far as good luck trying to get out of one if you do enter into the contract. The biggest dispute that I see come up with the new build contracts are typically delays, and Jody, you probably have experience with that, is the build isn't going according to plan. It's taking longer than expected. And, the buyer has a lease that's ending and they're trying to put pressure on the builder, and they have some clause in there that, there is a anticipated deadline, but it's not real hard and fast. And so generally they are very builder friendly. So be careful with that. And I haven't seen a ton of explicit warranties in the ones I've reviewed recently. But if you want us to look at them, go ahead and send it over, and we can help you out. But typically it would be by contract first. And if it's not, then the civil code does provide some statutory ones that are helpful.
My dad worked for a home builder as well and used to walk the new homes, and you'd make those punch lists of things that you see, and even up to a year afterwards, he'd have people calling for certain things, and you just have to decide, is it normal wear and tear? Is it, where does the fault, I guess, if you would say, lie?
Yeah.
I'm trying to get, if you're taking a buyer out to look at a home and you realize that this is a flipped home, it's obvious that there's shoddy work, things like that. Are there things that you can do as an agent to report that, to let somebody know that this is not going to end well for somebody?
That's a tough one, because one of the bigger concerns I see is that, say you have a buyer come in, and this is important for sellers agents to know, is you have a buyer come in and they do a home inspection report, and, or they have a contractor come in, they say, hey, this wasn't built to code, and there's documentation that's provided, and it's used in some kind of price negotiation, right? The buyer's like, hey, I accept that you didn't build this gazebo with a permit, whatever it was. And the seller got those documents, and then they're like, you know what, kick rocks, we're not selling to you, we're not decreasing the price. Now, as a seller and the seller's agent, you have a duty to disclose that information to a subsequent buyer. And so you get in a situation where this information is coming in and people are calling stuff like that out. You just want to be careful as a seller, because if that's material information that maybe you didn't know, which I don't really buy that. They probably know that it was some, cheap labor, and that's kind of how it goes. But the biggest dispute, number one, would be non-disclosure for that issue when you get that information. We just had a case where our clients backed out of a transaction and the deposit was up for dispute, right? And they got a foundation report because the driveway was having issues. They couldn't really get in and out easily. And they gave that report to the sellers and said, hey, this wasn't disclosed. We're backing out. We want our deposit back. You knew about this. Well, the sellers were in contract with previous buyers. Those buyers backed out, and same issue, right? They had told the sellers that, hey, the cost of repairs are too much. We don't want to buy it. But they had a contingency, so they backed out. Our clients got in, same deal. They didn't receive those previous buyers' information. And now it's this chain. And then now the sellers resold, but they resold to the previous buyers, which is kind of odd. But I think the intention behind that was so they didn't have to update their disclosures with all this new information of the shoddy work and the way the driveway was poured. I think that one is so ripe for a lawsuit. If a buyer came to me and they were the subsequent buyer, and we found out there was a report from people that decided not to purchase based on the performance or the work performed, you're dead. The seller is just, they're going to be hosed on that part. Yeah.
So I guess my next question would be, what's considered a flipped home versus I remodeled the kitchen? Is there a threshold of how many rooms you do or how much money you spend that makes it remodeled versus flipped?
The distinction to me, and James can add his opinion too, is that It's generally where they did not live in the property, and so it was bought as a fixer-upper, and sometimes they do if it's a long-term remodel, but it was bought and literally it's a ticking clock to where they can resell it. So they're literally lining up vendors right away. They gut it's substantial compared to a seller that lives in a home and they redo the kitchen before they sell the property. That's not really a flip. It's people that are buying it and offloading it. What that time frame looks like, I would say hopefully less than a year. I think you could do a flip in that time, depending, COVID, I'm sure slowed it down. But I would, in my mind, is the distinction of they're not buying it as a residence. They're buying it to resell after renovation.
And, I know a lot of people watch, I'm going to go back to HGTV and DIY Network, there's this, I want to call an illusion maybe that you can get these houses for cheap that really do need the work, and put your money into it. So do you find that these are truly like just individuals that are purchasing these things and flipping them, or are you seeing that they're real estate agents that are doing it?
Sometimes it's these, investment companies. So it's a partnership. So it's like 4 or 5 guys that, one guy's a contractor, one guy's an investor, and it may be some kind of LLC where they form. It's definitely less common to get, a single person just buying it. I mean, it does happen, but it's usually they kind of run it as a business, as they have funding, they have vendors that they already know and use, and it's kind of like that's their course of business, is they flip properties. That's more common, certainly, and that's part of what I was trying to describe, is that there is a lack of ownership, or a lack of pride in the property when companies are doing that, because all they see is their purchase price and their resale price, and the quickest way to that resale price for the lowest amount of work performed, at the cheapest cost. I mean, honestly, that is sometimes the case, and that's why you have to be very careful as the buyer. Yeah.
Awesome. Well, I don't, there is a question in here, and I have avoided it, only because it's not on our topic, but, let me update, the person is still here. So I know we're at 2:00. I'm going to ask this question. This is probably for you, Ashley. I need to sell a property in which I have tenants in place. What is the COVID government requirements as far as termination of tenancy and notice? Their 1-year lease is expiring June 15th. And we'll probably have you back, because I think the current moratorium is June 30th, if I'm not mistaken.
Well, biggest question, looks like Ivana is their name, is what kind of property is it? Because it's important to know, under just cause laws, expiration of a fixed term lease is not just cause, and so you would have to be exempt from the protections of the just cause law. So number one is I would need to know what kind of property it is. If it is a single family property and everything checks out, the biggest thing you don't want to do, Ivana, please do not do it if you intend on getting them out, is do not accept rent after expiration of the lease, because then what happens is you will have to serve likely a 60-day notice, and otherwise you probably don't have to serve any notice. The way the car lease is drawn up in most leases is that it terminates automatically. The only way a month-to-month is created is by acceptance of rent. And so I would reach out to me specifically though, Ivana, and just, I would need more details about the property, and then also just what the lease says. But number one, don't accept rent. And number two, I would need to know what kind of property it is.
Yeah, these landlord tenant things have gotten